All right, I guess we can begin my portion of the presentation, which unfortunately is not nearly as interesting as Stephen's presentation. That's that recording. Okay. All right, I'll try to talk as loud as I can. Can you hear me in the back now? All right, so we'll move on to my presentation. I'm going to talk about contracts in the cannabis industry. Unfortunately, I don't think my presentation will be nearly as interesting as what you just heard from Stephen, but I'll try to keep it entertaining, and if you have any questions or want to interject in the meantime, please do. A little bit of background about myself. I am a partner at Hodgson Russ. We are a law firm that is headquartered in Buffalo, New York. We have locations in several different areas, including Albany, Saratoga, and we're in Florida and Toronto. And one of our new emerging industries is the cannabis law practice. My personal background, I have been somebody that was involved in and continues to be involved in the horse industry. I own, I ride, I handle, I have a boarding stable of Arabian show horses. And after I started at Hodgson Russ and got my feet wet, I started the firm's equine practice. And that quickly then turned into the agricultural law practice. And now with the new developments in the cannabis industry, we have a cannabis law practice as well that I am the head of. So today we're going to talk about contract concerns in this emerging industry. And what I want to talk about today is that there are really unique issues that this industry faces. This isn't an industry where you can jump on Google, you can find a form contract, and you can use that. This isn't an industry where you can have a handshake deal. How many people here like to do handshake deals still? Okay. That's something that is going to be and could be very problematic with the unique issues that are faced by those that are in the cannabis business. And why is that? Because the industry is highly regulated. That's something that we just talked about for the last hour, and we need to make sure that we are complying with all the regulations, state, local, federal, which are often conflicting and always changing. Always changing. That's the one constant in this industry. So, what's going on today is going to be very different than 2 months from now, 6 months from now, 2 years from now. So your handshake deal or your form contract, it needs to be a flexible document. You need to be able to adapt as changes in the industry adapt. So we'll talk about that a little bit later on. There are many different types of contracts in the cannabis industry. Many of them are standard, same as any other industry that you may participate in, but they're going to be unique because of the regulations that we just mentioned. So let's start with some of the primary categories. The internal governance agreements. So these are the agreements that, if you have a startup company, you're going to need... Sure, I'm already getting a dry voice. So whether you have a startup company or an existing business and you're creating a new co, you're going to need to get that company incorporated, and you're going to need to have an operating agreement. You're going to need to have bylaws. You're going to need to have shareholder agreements. And these all need to address the unique issues faced by the cannabis industry. Distribution agreements and supply agreements, those are the big ones. Growers agreements, you probably all have those right now if you're engaged in the agriculture industry. They will have some unique terms, which we're going to get to shortly. Testing agreements, again, because of the regulations in the industry, there's going to be testing of the product. We're going to need to make sure there's no contaminants, the THC content is accurate. So we're going to need to make sure that we have agreements appropriate for that. Asset purchase agreements. One of what we're noticing at the firm is that there are existing companies that might be in Colorado, in Oregon, California, in Canada. So what we need to do is move away from that. The subject matter of this contract is a legal court you can't enforce it. We don't want to address that. You want to have a contract that if there's an issue, you can take it to court, you can enforce it, say they're in breach, and I'm entitled to X. Maybe you want specific performance, maybe you incurred damages, but you want to make sure that this contract is good and you can enforce it. So choice of law and venue. What that means, choice of law means what law is going to apply. Are you going to have New York law apply, or are you going to have Colorado law apply? If you are in the cannabis industry and you are working on an adult use product, you don't want New York law to apply. You want Colorado law to apply. So that's important. Venue, exact same issue. What court do you want to be in? Do you want to be in New York or do you want to be in Colorado? In that case, you want to be in Colorado. Now, another reason for choice of law and venue, and this is actually a must, not a should, where are you licensed? In that instance, if you're in the business and your product is going for an adult use product, you're not going to be licensed in New York. You're probably licensed in Colorado or Oregon or California, etc. So that's where you want to make sure you're going to sue. Oftentimes in contracts, it might be a convenience factor that, one party's in New York, one party's in Colorado. The company in New York has the higher bargaining power, and they say, no. If there's a dispute, we're going to sue in New York because that's convenient for me, and the other party says, fine. That's not the case with cannabis contracts. Acknowledgement of subject matter and waiver of defense. This is something that you want to make sure that contract speaks to what it really is. You don't want to just say, I'm growing a crop. What kind of crop are you growing? This is for cannabis. This is for hemp. This is for medical marijuana. What kind of crop is it? And you want waiver of the illegality defense, because that's the defense that can void your contract and mean that you can't ultimately enforce it. But if both parties say, no, if we're in litigation, we're not going to raise that defense, then it's enforceable. Indemnification and limitation of liability. These are huge, and you wouldn't believe how many times these provisions are missing from contracts or they're just not properly drafted. And what this goes to is who's going to pay for a problem. So let's use a hypothetical. There's a retail store, and they are selling baked goods with THC. And they have a consumer who comes in, asks a ton of questions, and they decide that they're going to buy a candy bar that contains the legal limit in that state of the THC. And they consume it in the parking lot, they love it, they finish it, and they proceed to drive down the highway to wherever they're going. They're high. Too much THC in the candy bar. They get in an accident, they injure themselves, and they injure others. 1 month later, there's a lawsuit. The lawsuit names the retailer, the distributor, the manufacturer, and the three of them are saying, well, it's not my fault, you're going to pay for this. But all three of them are named in the lawsuit. So how does that work? Well, the first thing you're going to look for in that instance, if you're their lawyer, if I get that complaint, is what does the contract say? Who's taking the risk of this mistake? It was a mistake. It was not intentional conduct, but certainly someone screwed up. There was way too much THC in that candy bar. The manufacturer there is likely the one that's going to take on this risk. You want to make sure that that is in the distribution agreement, the supply agreement, whatever agreement is in place. Otherwise, what may end up happening is it's just split a third. Once let's say there's a $2 million verdict. You don't want to be on the hook for that if you're the distributor. You're just selling and marketing the product. You don't want to be on the hook if you're the retail store. You didn't make that candy bar. You simply sold it. So the goal, it's always to shift the risk. Of course, there is bargaining concerns here because both parties are likely going to be represented by lawyers. The lawyers are going to be representing their client's interests. And my goal, if I'm representing all of you, is I'm going to be shifting that risk to someone else. Their attorney's goal is going to be shifting it back on us. So ultimately what ends up happening is you indemnify yourself for your own negligence. And that's why in my hypothetical, it's likely the manufacturer that that would take on the burden of that lawsuit. But here's what's really important. You want to have coverage. And a lot of the contracts should speak to insurance coverage. You need to have it. And you also need to name the other party as an additional insured. I'm not an insurance broker. I'm not an expert. But as an attorney, it's the first thing I ask my clients. What kind of liability policy do you have? And we try to get you coverage. Sometimes you'll have it. Sometimes you don't. It depends on what happened. What is the subject matter of the lawsuit? There's a lot of different coverage that is available for cannabis businesses. Coverage is typically at a premium in this industry. It's typically more narrow. But it's always advisable to call an expert in that specific industry. And there are insurance companies that do specialize in cannabis companies, coverage for cannabis companies. So that's something that, whether or not it's in your contract, it's something there that can certainly help you out if a problem arises. Okay. Any questions? Yeah, no, I think that's exactly right. That is what I would advise my client, is that they do have no trespassing signs up, or they take reasonable measures so that trespassers could not come onto the premises. But they are trespassers, and they don't get any protection under the law because they stole your crop. So yes, it could end up being a huge headache for you down the road, but that's another reason that you also want to have a commercial liability policy. Sure. Mm-hmm. Right, right. And you can only take reasonable measures. I mean, you can't you can't take all measures to prevent something from happening. So the way a court would look at that is, did you take reasonable measures? But it's always advisable to put up those no trespassing signs. Yeah, and that would be just that's your typical marketing type scenario, where you're going to need to make sure that you're selling to markets where it's legal. That's internet marketing? That's what the business would be engaged with. So again, you need to make sure that you're in compliance and that you are marketing that product to the appropriate audience. And what you might need to do on that website is prohibit sales of certain products in certain areas in order to make sure that you do abide with the law and regulations. I think you've probably seen on certain websites where it says this product is not available in the state of New York, or this product is not available here or there. That would be why. Mm-hmm. Yep, and that's what I was saying. Like with the lease agreements, when you're entering into lease agreements, if you're exactly a lot of the contract stuff is the same, but there are additional measures that need to be taken and taken into account when these contracts are being drafted. Okay. If anyone has any questions afterward, I'll stick around for a little bit. We're very happy to do it. And you know, as a firm, it's actually it's quite interesting the issues that we've already faced. Even though in New York, you know, we're not quite as far along as other states. You know, we are involved in. I'm not sure if y'all heard of the Buffalo Waterfront project that you know is ongoing. That's something that we're involved in. But you know, we have clients that are all over the country and in Canada that are looking to get into this industry. And it's, you know, it's an exciting time, and we're happy to be involved.